Good afternoon. We're about to commence the public hearing. Once again, if you wish to testify, there's a sign-up sheet at the table by the door, and we'll take the testimony in the order that people are listed on that sign-up sheet. I will now call the public hearing to order, and the Barnstable County Assembly of Delegates will hold a public hearing to amend chapter on proposed ordinance 11-04 to amend Chapter A, enabling regulations of the Code of Cape Cod Commission Regulations of General Application, Barnstable County Ordinance 90-12, as amended to include Section 3.0, and proposed ordinance 11-04 to amend Chapter A, enabling regulations of the Code of Cape Cod Commission Regulations of General Application, Barnstable County Ordinance 90-12. Oh, it's the same one, isn't it? Sorry, I've got the wrong one. To amend Regional Policy Plan per Section 8H of Chapter 716 of the Acts of 1989 as amended, and I will explain that as we go along. Okay? This meeting is being recorded, and it will be available online for anybody who wants to review it. I will now ask the members of the Government Regulations Committee to introduce themselves. I'm Ron Bergstrom, Speaker and Chair of the Government Regs Committee.
I'm Dick Anderson, Deputy Chair from Bourne.
John Oman, Chair of Finance from Dennis.
Did I say that?
Julie Taylor from Falmouth, Chair of Natural Resources.
Paul Pilcher from Wellfleet, Chair of Economic Affairs Committee.
Chris Canega from Orleans, Health and Human Services.
Okay. There are actually two ordinances which are the subject of this public hearing, but for one is comes out of an initial ordinance presented to us in November of last year, was remanded back to the Commission, and they have in turn passed regulations that resulted in these ordinances. The one ordinance is thresholds. So we're talking about 1104 as the thresholds under which a wind turbine becomes a development of regional impact, and the other ordinance is enabling regulations, standards and so on, and that. But for purposes of testimony in this hearing, we're going to consider it as one issue, and so you don't have to identify exactly what ordinance you're speaking to. We know why we're here, and we understand what we're talking about. We're talking about whether or not the Cape Cod Commission is going to take under its jurisdiction any wind turbine over a certain size, 65 feet, and if it does, what standards are they going to use to judge those standards, height, distance from abutters, and so on. Copies of these ordinances should have been made available. This is an amendment to the Regional Policy Plan, and we have copies up at the desk of the specific amendments and the changes in the Regional Policy Plan for anyone who hasn't already seen them. Okay. I will now begin taking testimony, and first I'll ask if there's any testimony from federal officials. Okay. Is there any testimony from state officials? Okay. Is there anyone testimony from county officials? Yes, recognize County Commissioner Bill Doherty.
For the record, my name is Bill Doherty. I am a chairman of the Barnstable County Commissioners. I am here as both as an individual and in my official capacity, I guess, to speak my opinion with regard to the proposed regulations. I will give you a copy of my testimony afterwards, and I would like to read it into the record. The proposed Cape Cod Commission amendment to Regional Policy Plan on wind turbines. General, if it is intended to be a clear and unambiguous statement of thresholds which gives a reasonable degree of predictability for positive outcome if the applicant meets the standards, I find that it fails in the area of noise level measurement, effective flicker, fall zone, and height related to the ratio of economical construction of electrical output. With regard to noise level measurement, The suggestion that two consultants could give a compatible yet alone an identical assessment. The state has said that they will not issue standards until after they hire a consultant to develop a useful methodology to make such a measurement. From a point of view of personal experience as a technical staff member at the Human Engineering Laboratory at Aberdeen Proving Ground, where I was tasked with measuring high-intensity steady state and impact noise, we attempted on many occasions to develop a simulation or estimating method. We were not able to replicate in situ output of actual operational equipment in the 3 years that I was there. Therefore, it is difficult for me to believe that any number of consultants' reports would lead to accurate levels of predictability. In my opinion, the regulation as written will lead to litigation. Flicker standards are a function of being managed so that they have no effect at all. Clearly, an arbitrary method of allowable flicker does not take into account the subjective nature of the subjects that are affected. In some cases, it can be irritating, and in some, completely intolerable. The fall zone and suggested tower height parameters effectively reduce the economic viability of the wind turbine. Although the question has been asked many times, the Cape Cod Commission has not answered exactly where exists the places on Cape Cod which meet the criteria as stated in the amendment, and how many turbines in total can be accommodated on Cape Cod. And finally, the fact that there are other agencies that are part of the county's investment in alternate and renewable energy that have not signed on indicates that many questions have yet to be answered. And I will give you a copy of my testimony.
Thank you. Okay. Yes, recognize County Commissioner Lyons.
I'm Sheila Lyons, and I am here as Sheila Lyons, not as County Commissioner, and I do just want to make for the record that although Commissioner Doherty did identify himself as the chairman of the County Commissioners, and he was here in somewhat of an official capacity, that was his own personal opinion, and he does not speak for the other commissioners on the board. Thank you.
Thank you. Okay. Is there any local officials here to wish to testify? Yes, I recognize the chairman of the Brewster Board of Selectmen. I'm asking everyone who speaks to identify themselves, even though we know who you are. Folks out there in TV land are not going to know, unless you tell us.
For the record, my name is Ed Lewis. I'm the present chairman of the Board of Selectmen for the town of Brewster. And I speak in opposition to these regulations, and opposition to it because effectively what it does is ban wind and that form of alternative energy on Cape Cod. I respect the Cape Cod Commission, everything they do. I'm a big advocate for them, but in this instance, I feel what they've done is they've put regulations in force which will make people not be able to have wind development and not be able to use it on Cape Cod. The idea, as Mr. Doherty explained, the idea that you're going to get two consultants to agree on something so that as part of the regulations doesn't make any sense to me. We've gone through a process in Brewster with regard to wind turbines, and there are those who are against wind turbines. Most of them in Brewster are within a certain number of feet from the wind turbine, and they have presented expert testimony which helps their cause. And at the same time, Brewster and CVEC, which is has contracted with us or is contracting with us, we've presented expert testimony which flies in the face of what the opposition has shown expert testimony, and that involves noise or sound, and that involves flicker, and that involves effect on real estate values and anything else that you can come up with. And effectively what this will do, if these regulations become law, is there will be no turbines on Cape Cod. I know that the commission has said, well, we'll work with you, and it just isn't going to work. It becomes overly expensive, and it becomes impossible, and it leaves too much open to the opposition coming up with all kinds of legal challenges based on what's in the regulations. And I think it's best left up to, at some point in the past, we've always talked about we want to be local, and we want local, on Cape have an opportunity to govern what we do as against the state. Well, when you take these regulations, we're local, but the commission and you, the Assembly of Delegates, if you were to pass this, you would be the state, and you would be telling us what to do. And I think that in this instance, the individual towns can govern themselves. They have regulations, and they can, through zoning, they can help themselves, and they don't need these kind of regulations. Thank you very much.
Or any other local officials?
Dan Rabel, Selectman from Brewster.
You have to identify yourself.
Thank you. I'm Dan Raybold. I'm a selectman, town of Brewster. I've read through the proposed standards, and my main objection is in the noise standard, which relates to rotor diameter as a measurement of sound, which I don't quite understand how sound, which is measured in decibels, is going to be then compared against a physical length of a metal object. I know that the commission is trying to do what they feel is right for the Cape in sort of reviewing projects of this nature, which I had no problem with. I just find the standards that they're proposing don't really fit with what they are trying to measure. That's my biggest complaint with these proposed standards. I would have loved to have seen in the noise thing something relating to decibels, which is how you measure noise, and there isn't any. Shadow flicker refers to shadow flicker events. There's no definition of shadow flicker events and what that actually means. So once again, these regulations, which I believe the impact of what they're trying to accomplish is well-intentioned, leaves it very open to a subjective analysis. And I don't think you can put into place regulations that are subjective, because then it becomes someone's opinion. And if you're going to propose regulations of this nature for this particular type of project, which are wind energy turbines, you really need to have something that measures something as opposed to a subjective analysis. Also, technology is going to change. I don't know if you're familiar. There are things called vertical access wind energy turbines, which this doesn't address. They have cylinders rather than blades. So therefore, if you have a regulation that says 10 times the rotor diameter and a wind energy turbine doesn't have a rotor diameter and it makes a noise, how are you going to measure that or use this regulation to decide on that type of a turbine? There are just too many areas within this regulation that are not going to be able to be properly assessed by people, and that's my objection to them. Thank you.
I'm required to notify you this meeting is also being recorded by members of the media as well as our official recording. Is there any other local officials wish to testify? Yes, Town Manager from Brewster.
Thank you. My name is Charles Sumner. I'm the town administrator for the town of Brewster. And you've already heard from a couple of officials from our selectmen for the town of Brewster. I don't want to be repetitive. I am just very concerned about the nature of the regulations in terms of the ability to develop wind technology on Cape Cod, period, particularly when you look at the issue about the 65 feet height. And we have three homeowners now who are either building small-scale wind turbines in Brewster. They already have permits from our Brewster Planning Board under our special permit bylaw. And I just think this process is just going to prohibit the development of small-scale wind turbines just because of the cost and expense and process and the risk that someone's going to have to go through for the process. I share the same concerns that were referenced by the two previous speakers in terms of some of the guidelines and standards in the regulations, but more so I wanted to talk about Brewster in particular. We have spent over a year and a half designing, and permitting two turbines on Freeman's Way in Brewster. We've spent over $500,000 to date on this project. We are about to file an exemption with the Department of Public Utilities based upon a procedural denial by our planning board under our zoning bylaws. Vote was 3 in favor, 3 against, 1 abstention. And so these regulations don't recognize the fact that the town of Brewster has already in process filed our application for our permit last fall, gone through permits all winter. And I just think that there should be recognition that we are already in process. We should be protected from these regulations. I did call the Cape Cod Commission office when I first heard about these regulations and didn't receive a satisfactory explanation about how Brewster would be protected. I don't think we will be. All that we have spent in money and time and energy and a great deal of support from the Brewster Town Meeting will be lost with the adoption of these regulations.
Okay, thank you.
Thank you.
Are there any other local? Sure.
Excuse me, are you saying that the proposed permitted, somewhat permitted wind turbine would not meet these regulations? It wouldn't, it would be higher than 65 feet, so it would come under it, and it won't have a cleared base under 1.7, and it won't have the setback greater than 10 times the rotor?
That's correct. With a number of...
Planned it for what, 5, 6, 7, 8, 9, 10, do you know?
Well, there are a number of areas where we would not meet these standards, and I've said we've already gone through our design, permitting, and a great deal of expense already before these were even crafted. But there are a number of areas where we would have problems with these regulations.
Flicker?
Yeah, flicker, yes. Setback, yes. Diameter, yes. Yeah. Thank you very much.
Mr. Summer, can I ask a quick question, too? What exactly did you pass at Brewster Town Meeting to indicate that the town supported wind turbine energy?
Well, the town of Brewster has provided the Board of Selectmen with the authority to lease land in the Brewster Commerce Park and Freeman's Way to construct two, what are 410-foot turbines on the Brewster Commerce Park. So the town adopted regulations under our zoning bylaws for a special permit process, and they have authorized the Board of Selectmen to lease land for the construction of two wind turbines. So there's been a number of even procedural amendment votes over time. For example, we had to go back to town meeting to increase the time frame for the term of the lease from 15 to 20 years. So we've been to town meeting on several occasions.
And were these majority votes, or because it's zoning involved, did you have to even get a two-thirds majority?
Well, the original article to create the wind turbine district was a two-thirds vote, and that vote was so overwhelmingly supportive that we didn't even have to do a count on it. And the moderator has the ability to make that decision. So that vote wasn't even close. We got such a large majority, significant vote at town meeting. The same thing on the votes in terms of authorizing the Board of Selectmen to lease land to this case to the Cape and Vineyard Electric Collaborative was a majority vote. The vote was so overwhelmingly supportive that we didn't even have to count those votes on a few occasions. Thank you.
Thank you. I'm going to now recognize the Cape Cod Commission. We're going to give a brief presentation so that we all understand exactly what we're talking about. And so, the Executive Director of the Cape Cod Commission.
Good afternoon. For the record, my name is Paul Neswicki. I'm the Executive Director of the Cape Cod Commission. To my left is Ryan Christenberry, planner of the Cape Cod Commission. To my right, Jessica Wilgus, Commission Counsel. We have a brief presentation for you today on the thresholds and the standards that are in front of you. I just want to preface the presentation by reminding the Assembly that we were in front of you in November, and we had 3 fairly general standards proposed at the time. And that was an effort to close a loophole in the regional policy plan. We have some large-scale commercial wind projects now that are tripping commission review for reasons other than the turbines themselves, or the height of the turbines, certainly. And we have no existing standards to review those projects against that relate to the wind turbines. All we have at the end of the day is a benefits detriments analysis, which I would suggest is not fair to the applicant, because it doesn't provide a clear and certain presentation of what we're going to be measuring, and unclear also to people that feel that they are potentially impacted by these. The irony is that by sending them back to us in November, there's still nothing on the books, and there has been a large commercial scale presentation on the Cape that has withdrawn and then resubmitted. So had those standards been voted in November, they would be applied against the project now. But we're not doing that. This was a very emotional discussion we had back in November, and it has led to this sort of, I think, result that's 180 degrees out of what the purpose of and the discussion was that we had in November. So we have, I've reviewed the tape of that meeting several times. I've got a transcription with me here today, and I think we have responded and given the Assembly exactly what you asked for, which was a threshold and more specific standards for that application. So I want you to consider the standards that are in front of you today and the thresholds that's in front of you today and the meeting in November, and understand that we came to you in November with standards that had been through CVEC and Cape Light Compact and were deemed to be not strict enough. And one of the quotes at the end is me saying you're going to hear from your town managers, your town administrators, and your boards of selectmen on this issue. And when we come back with a threshold and standards, the conversation is going to be different. So in that context, we want to go through a brief presentation today. I do want to just correct some of what has been said initially here, just to answer that. I mean, we deal with dueling consultants on issues all the time. I mean, that's not something new for us to deal with. And as it relates to the Brewster turbine, the regulations that we have were never intended to apply to that project. We had anticipated a different trajectory on that project, and we can't answer for some of what's happened or some of what might happen, but it was not intended to apply to the Brewster project. And part of the reason we didn't come back with a threshold in November, we didn't forward one, is we were just trying to close that gap in the regional policy plan that applied to projects that tripped Cape Cod Commission review for other reasons. We would have considered thresholds for land-based consistently with the ocean DCPC and the offshore regulations that we're developing now. And it wouldn't have come this quickly but for the request of this body that we act in a timely fashion. And I think you remember the feelings were so strong in November. That was a call from one of your now former members for a DCPC Cape-wide, which I didn't think was appropriate at the time and still don't feel it was appropriate. I thought we could get you reasonable regulations in a timely way, and that's what we've tried to do. So as a preference to Ryan's presentation, I just wanted to put that in context.
Before you begin, of course, I have reviewed the transcript also, and I did speak very strongly in favor of a threshold. I don't see anywhere there that anyone on the Assembly suggested a particular threshold, neither height nor number, or there was no suggestion by anyone on the Assembly as to that height. So I'll just get back to that. Nor was there any suggestion by anyone on the Assembly as to what the setback for residential property might be. So while, yes, there was definite sentiment for a threshold and for noise setbacks, we didn't make any specific suggestions. Are you implying that these are not heights and setbacks that you can defend in some way, as opposed to saying that there are suggestions? I mean, I'm still in favor of setbacks, and I'm still very in favor of a threshold.
No, I'm not suggesting.
I don't have any technical reason for choosing this or that. I'm assuming you do, and that you're going to make
Ryan's going to bring through that. There was a discussion about height related to the threshold in the discussion. There was also some fairly specific suggestions by an attorney at the time, Chris Senni, who seemed to have a lot of support, vocalized on that tape, specific to thresholds, the kind of thresholds that would necessary, and some of the height stuff, referencing cell towers. And what Ryan's going to explain to you is that when the commission looks at a threshold, we have to put it in the context of the entire regional policy plan. And so what you're going to see is we have to ask ourselves, okay, what are wind turbines like? They are like cell towers, for example. In order for that regional policy plan to be a legally defensible document and to treat like things the same, that's where the threshold comes from. Now, a lattice cell tower at 35 feet triggers commission review. A monopole structure at 80 feet triggers commission review. When you take into account the vertical and horizontal impact above the average tree canopy, 65 feet is where you land. So that's where it comes from. What I would say in addition to that, there is a provision in the thresholds now whereby we can come forward with a subsequent ordinance that would allow towns to have local wind bylaws certified by the commission and adjust that threshold based on your local bylaw. It actually gives that back to the municipalities and gives that flexibility there. But 65 feet is all that you're going to get out of the commission. To go any higher, any lower than that is a political decision, and not one that I think the commission feels comfortable making, although they do feel comfortable giving the individual municipalities the ability to make that decision. And I think, so a lot of what you're going to hear today is probably not what you've heard to date. I haven't, other than having a discussion with the delegate from Sandwich on some general issues this morning, I don't think I've discussed these with any of you.
There's some other questions from the committee, but at some point, it would be in the public's interest if we gave the presentation first and then some questions, so that we know.
So with that, I'll turn it over to Ryan. Thank you.
Thank you, Paul. Mr. Speaker. Again, for the record, my name is Ryan Christenberry. I'm a planner with the commission. As Paul mentioned, we began seeing projects trigger existing DRI thresholds in about 2009, wind facility projects. We didn't have standards on the books at that time, so after some review by commission staff and our planning committee, we put forth to you in November 3 standards that pertain to safety, noise, and shadow flicker. At the time, there was a much-informed discussion that included the potential for this land-based DCPC idea, but ultimately the Assembly determined that the performance standards as proposed were not restrictive enough, and that they may be lacking in some sort of trigger for regulatory review. The vote by the Assembly at the time was to remand the standards back to the Commission for further study, which we have done. Beginning in January, the Planning and Regulatory Joint Committee held 4 meetings. There were 2 Cape Cod Commission meetings in addition to that. And on February, the full commission approved the revised standards and thresholds, and they were submitted to you for consideration on March 16th. I will basically run through first the threshold and then the standards. The detailed text of each is provided in your packets and is available, I believe, for the public on a table at the back of the room. I provided a summary just to get to the meat of what the standard and threshold would do, how it would be applied. As Paul mentioned, the 65-foot trigger for DRI review is consistent with our existing regulations for cell towers. There is a provision there for the Assembly to adopt an ordinance so we could set up a process for the Commission to certify municipal bylaws and provide some relief under that height threshold if that's your wish. Again, the lattice-style cell tower threshold for cell towers was 35 feet when it was initially proposed. A couple of years later, it was revised to add the provision for monopoles at 80 feet. And I can provide you with some of the Commission's track record on reviewing and permitting cell towers as DRIs at the end of this presentation, if you'd be interested. I have that data. So there are 6 proposed minimum performance standards. This is a separate ordinance from the threshold. This is Ordinance 11-04. These performance standards deal with clear area noise and shadow flicker, essentially the same topics from the prior version that we put before you, with an additional standard of decommissioning. There is a standard that addresses a municipal waiver for turbines of a certain scale, and then we've requested a modification to an existing community character standard that would require visual impact assessments. The clear area remains 1.5 times the height of the wind energy facility. However, the provision for negotiating reduced setback has been removed due to safety concerns expressed over blade throw and ice throw. The clear area definition states that this standard applies to structures designed for human occupancy. So this was the previously proposed safety standard. The noise standard has been revised to include a 10 times the rotor diameter setback for turbines greater than 660 kilowatts. This is consistent with some regulations that are coming out of the state of Wisconsin as rotor diameter as a measurement of turbine setback. It's intended to be not a decibel level requirement, as this is more effective in a spatial planning exercise in the permitting phase of any project. The provision for the noise study remains as part of this standard, as well as the possibility of a reduced setback based on the noise study and a commission consultant's review of that noise study. The shadow flicker has been revised to include a requirement for a shadow flicker study, as well as a mitigation plan that would outline how that project would limit its impacts on any receptors to less than 10 hours per year. And the way shadow flicker studies are conducted, that's fairly easy to model and outline a mitigation plan for. The decommissioning standard is a new proposal. It would require 120-day, any facility not in operation for 120 days would require decommissioning unless a waiver is obtained for good cause shown through the Cape Cod Commission Executive Director. Security and a decommissioning plan are also components of the standard that would be required during the permitting phase. We've proposed a waiver for municipal projects of 250 kilowatts or less. This waiver would be applied to the noise, flicker, and decommissioning standard. The clear area setback, however, would remain in place. And finally, the existing community character standard for scenic roadways and vistas is proposed with a slight revision that would just may, on a case-by-case basis, require a visual impact assessment of that project if it were to potentially impact scenic resources such as scenic views, vistas, etc. So a quick summary of the differences between what we proposed in the fall and where we are today. There were 3 standards in November, one for safety, noise, and then shadow flicker. Today we have 4 MPSs. Those 3 for clear area, noise, and shadow flicker have been refined to be more specific. The decommissioning is a new standard. There's a municipal waiver, modification to an existing MPS, and a DRI threshold as proposed as a separate ordinance. These are definitions that are contained within the RPP provided in your packet that would accompany this regulatory language. Next steps obviously involve forming a working group to go through the technical bulletin, and that concludes my presentation. I'd be happy to answer any questions.
Any questions from the members of the committee? Paul?
Hi, good afternoon. When you were here before us in November, you were talking about technical bulletins that would accompany these regulations. Mm-hmm. Am I correct in presuming that there would continue to be technical bulletins that would flesh out some of the ambiguities that people have remarked upon?
Yes, there would be a technical bulletin, and for the first time, we would put together a citizens advisory committee to monitor the construction of the technical bulletin, round that out with people that would monitor and contribute to the process. We've talked to the State Clean Energy Center. Yesterday, I had a conversation with the Commissioner of the Department of Environmental Protection, the Secretary of Energy and Environmental Affairs, and let them, and so the state has agreed to participate in that process.
Julia?
Am I right in thinking that some of the reason for switching the noise standard to this distance standard that has to do with the rotor is because there's a relationship between rotor size and noise?
The suggestion for using a multiple diameter, the rotor blade, came from several parties at the same time, one of them being the Clean Energy Center and the state. The reason that that's there is that is a rebuttable presumption. So it's there for the purpose of the applicant to know what the expectations might be based on the height for a safe point. But it's ultimately the noise study that will be determinative of whether a project goes forward or not. So that 10 times the rotor diameter is really a spatial planning tool for people to use. It is not an absolute prohibition. And it does not suggest any sort of necessarily any technical competencies associated with noise or some of the other impacts.
To follow up, so if you had the noise study, it might turn out to be 5 times the rotor blade. It might, that you
Yeah, I think that the rotor blade is there initially as a spatial planning tool. If you took Brewster, for example, they would not qualify as being 10 times the rotor diameter. But if the noise study came back and their nearest receptor was 1,800 feet and the noise study was compliant, then they would qualify under the regulations. I think a lot of what I hear are these questions about costs associated with it too, and we've changed the fee structure, which you voted on a couple of weeks ago, and all wind gets sort of a discount, and those projects under 660 are free, basically, so the small ones that aren't charged, what's that, under 250 are free. And then it's $3,000 per turbine over on top of that. So, you know, Brewster would have paid a whopping $6,000 for the review of the Cape Cod Commission. And I just want to make the point that this isn't, I don't think this is a ban on wind, and it certainly wasn't intended to be a ban. But some sort of regional review, objective review of this project, I think might be helpful in having projects cited appropriately and more efficiently than the process that's in place right now. And so that is part of the motivation, and I think a sentiment expressed by many members of the Cape Cod Commission.
Yeah, thanks, Paul. The noise factors you're talking about are decibels. They're the large sound, if you will. What about the infrasound and the measurements that I've heard some very problematic issues with determining what they are and who they are to each individual person involved. And how is that measurable, and how defensible is that within your?
Well, it's an emerging field. You know, we look at sort of what the Vineyard Commission has done with audible noise. Did they do subaudible?
Yes.
Yeah. So there are some. The Vineyard Commission has actually established some acceptable decibel levels for both audible noise and I think subaudible too. It's emerging, but in my discussions with the commissioner yesterday, you know, he let me know that DEP and the Department of Public Health are doing a literature survey right now on that particular issue. Related to impacts and wind turbines, and we would expect that would be instructive as part of the development of the technical bulletin. And Ryan has just...
If I could just add to that a little bit about the Vineyards process. They worked with an acoustical consultant through a year-long DCPC planning process to arrive at what an appropriate decibel level might be, frequency ranges for potential infrasound impacts. So their process was very different from ours. I think that through the technical bulletin process, engaging an acoustical consultant who has expertise in this area is where we would try to define these acceptable ranges.
Just, am I right in thinking then for under 660 kilowatts, there is no noise rules or standards? Now, all applicants greater than 660 shall perform a noise study and adhere to the setback. So noise isn't operative as a standard for less than 660?
It is in the sense that my understanding of wind permitting projects is that all projects will prepare some sort of noise study. Once you get into the 660s or greater, the analysis behind that becomes far more technical, but there will be noise information available through the manufacturer specifications of the proposed turbine that will inform a noise component of projects under 660. Greater than 660, you're subject to the setback, and the noise study is a far more technical component of your permitting project.
Yeah, just to put up...
Subject to the setback if you can't prove that you don't have a problem with the noise.
Yeah, to put a finer point on that, which I think is an important one, what really shifts over 660 at this point is the relationship of the consultant. Over 660, an applicant's going to have to put up money like they do in cell towers, and the consultant actually works at the direction of the commission. Below 660, there's the standard process they go through where they develop their own noise studies and submit them as part of the local permitting process.
And this is something that's already done then for some projects? Cell towers?
Yes. The consultant piece is done that way for cell tower examination. The Cape Cod Commission puts out an RFP, hires consultants to come in, and they're available, but the applicant has to pay for the services of the consultant when they go through the review.
So this is trying to be consistent with that.
It's all trying to be consistent with that.
Well, give me an idea. Some of the complaints deal with the process, that it's onerous and it's expensive and so on. Give me an idea of where the Cape, and the public, where the Cape Cod Commission process fits in with the local permitting process. In other words, do you do this jointly? Do you wait until the local communities have gone through their process, or could there be a way of making the process not less onerous, but, basically shortening it so that you won't go over everybody's not going to go over the same ground 2 or 3 times. That's what
Right. When it triggers review, it will follow the same process every other project does that triggers Cape Cod Commission review. So the local process will be suspended. It will come through the regional process. There have been efforts at joint review around some other DRIs in the past, and that has met resistance. That was one of the recommendations of the 21st Century Task Force. The resistance has come from the towns who don't want that. They have their own timelines associated with review that they don't want to be impacted by joint review. So it's not that it would be impossible. Right now, it would delay it. But in the 3 years, unless a MEPA review is required, then joint is part of that process. But in the 3.5 years that I've been with the commission, projects don't take that long to go through. And so I think we could do, and if I look just at the projects that have tried to cite on the Cape, I don't believe that Cape Cod Commission review is going to be the issue that drags out these projects any longer than they really are. And I think everybody has to understand that you need to look at whether it's Orleans or Wellfleet or Harwich or Brewster or Falmouth or any of these other projects. None of them have had Cape Cod Commission review. We haven't played a role in land-based wind to date. So we haven't been a drag on any of those projects. And I suggest that if we have a process that's crafted appropriately, we could probably assist. Council reminds me that the wind siting reform bill that's in front of the legislature right now would collapse all local review.
So what you're telling me is that even in places like, let's say, Brewster, where they've passed a warrant article outlining a process, if these ordinances are passed, Cape Cod Commission basically will take precedence. You'll do the review process instead of the planning board and so on?
If it were a new project, I mean, the Brewster process now is in process.
Right.
And so to the extent that the process they've embarked on remains a single process, it's not subject to the standards.
Okay.
Now, if it collapses and they try to reintroduce it, and we have subsequently passed standards or a threshold, then that the possibility exists. But as I said earlier, it was not anticipated to apply to that project. It wasn't designed to apply to that project. As long as it remains one single process, it won't.
I didn't mean to suggest that it would. I was just using that as an example. Let's say Chatham had a bylaw, a process in place, nothing in front of us, but a process in place. Now your commission process would now substitute.
Yeah, the applicant would start the local process, probably go to the building inspector, try to pull a permit. At that point, they would be notified that they have tripped a Cape Cod Commission review trigger, and it would come to us, and the local process would be suspended until the regional process is complete.
So the idea that you'd have multiple layers, simultaneous processes, it's not going to happen.
Not simultaneous, and I would suggest that the Cape Cod Commission process is a fairly technical one and has a lot of information that is very useful to the local process when it returns. And so, I would suggest that a good regional review in many instances expedites the local permitting process, and in some ways insulates some of the political pressure that some of these local boards feel, especially when they feel like there's a lot of information and they haven't been able to sift through it. To have it already have been blessed by the Cape Cod Commission, I think helps.
Okay. Yes, Julia.
Now, I understand this comparison of cell towers and wind turbines. Oh, sorry. I understand you're making this comparison between cell towers and wind turbine towers, and I would like to hear about the result of review of cell towers. Would you consider that cell towers would be more dangerous than wind turbine towers and would need stricter regulations? Or
No, the only
do you think they're really very, very similar, or?
The only suggestion that we're making is that they share a similar characteristic that is already the subject of a threshold for Cape Cod Commission review, and we have to treat like things alike, and the law has to apply equally to everyone. At times, there can be political determinations made that give more leniency for one reason or another to particular things, and that has to go through a public process, and that might be what's engaged here. But I don't think the commission feels comfortable making a political determination about the height of turbines, but they do feel that that's appropriate to give back to the towns. And one of the reasons that they feel giving that authority back to the towns is appropriate is because the average tree canopy, which determines that threshold, varies depending on what part of the Cape you're on. So we have to draw the level at a certain height. Now, Well Feet, for example, has a prohibition on 25 feet. So they're pretty much on the record with where they stand on that issue. The other issue is that certain towns are large enough and have enough technical capacity that they can handle the permitting of smaller turbines. Other towns may not. Other towns may want that burden handled on the regional level. And I would point out that some of the more problematic wind turbines on the Cape, the ones that have thrown pieces of machinery, blades, are the smaller ones, not the larger ones. So that's also something that we have to keep in mind. And one of the reasons why we would want a certified local bylaw that had quality control built into it, so that the smaller ones are not, just by the nature of their size, less problematic. And all we want to do is make sure that the localities have taken those into account with a local bylaw, and then they can negotiate that height and make that political determination on their own.
Paul, just a point of clarification, if you would. What is the threshold for exempting a project that's in process? I mean, particularly we have the issue with Brewster, but is it a building permit? Is it a planning board approval, or is it actual commencement of construction? And where does that exemption appear in the plan?
I might hand this one off to council, but my basic understanding is and trying to explain it so that everybody can understand it, is that the regulation, if it were adopted, wouldn't apply to anything that was already in process. So it wouldn't apply to Brewster at all. So there's nothing in the regulation that provides an exemption for something that's already underway, because it wasn't anticipated that it would apply to that project at all. Now, as long as that remains one process, I think that's still the case. If there have been complicating actions, there have been actions taken in the town of Brewster that have complicated that interpretation, and I'll let council fill in the blanks on that.
Good afternoon. For the record, my name is Jessica Wilgus. I'm Commission Counsel. To respond to your question, where this comes from is directly in the Cape Cod Commission Act, which determines what projects come before us for review. It's not necessarily a permit is sought, but any type of permission is needed for that particular project that would require that referral to come back to us. That's what triggers our review. So when Paul refers to there being a single process, thereby there being no other permissions being sought for a particular project, it's not going to come back to us because there's no other permit or permission being pulled. You're welcome.
I'm somewhat confused. So there still needs another permit for the Brewster project. I don't understand where the process began. Where, if a process has begun, that you are now exempting them because the process has gone far enough. Well, Dennis had held a public meeting. The Water District held a public meeting 2 days ago. Are they in process? They've begun the process, but you still need to pull permits. And
that's where you're going to trigger Cape Cod Commission review. But, I mean, the Dennis project, you could anyway. You could have Harwich or Brewster refer it discretionarily even without standards. So, I mean, that's what I think everybody's missing that point. But if the town of Harwich wanted to refer the Dennis project to the Cape Cod Commission now without any standards, they could. And you, as the applicant, have no standards to know how we're going to judge you that is going to fall all to that benefits and detriments analysis. And I suggest that is not in the town's best interest if you want to move forward. So the permits have to be in process. Now, the Brewster, the reason I can't answer specifically is because I'm not absolutely up to date on what's happened in Brewster. There's been some sort of vote by the planning board, and there's some effort to create a new permitting process there. Now, that might trigger, if we were to adopt the regulations, that would probably trigger Cape Cod Commission review. But if there is an appeal that they can seek to the planning board approval at the state level, then no. So it's not that anyone's trying to be evasive. Part of it is a lack of specificity with what's actually happening in Brewster. And the other is that I believe there's probably more than one process that could take. One that might trip review if these are passed, and one that might not. But I would also remind the Assembly, because I hate to think that Brewster, a project that was not anticipated to be regulated by these, what's in front of you, becomes the tail that wags the dog here. And what you have in front of you is you have two ordinances you're going to have to vote on. One that sets standards, and the other that sets a threshold. And the threshold, you could split your vote on that. You could vote against the threshold and in favor of the standards to at least get some standards on the books. And the threshold also has a component of it, this provision for a subsequent ordinance by which towns could develop a local bylaw that would be certified and then set their own height threshold. And so if it were the Assembly's desire to send the threshold back to come forward only at the same time with that subsequent ordinance empowering the municipalities through this local bylaw certification, that might be an appropriate action to take.
Yeah. But if that were the case, if we sent the threshold requirement back, that would subject all wind turbines, regardless of height.
No.
No.
In fact, except for the discretionary referral authority that already exists.
Yes.
None of the thresholds would be subject to review over the trigger, and in fact, the Brewster issue would continue to play out. But without a threshold, that project is not going to be reviewed.
But when somebody else referred it as a discretionary matter, then those standards would apply.
Yes. So, and see, that's the rubs. If you take Dennis, for example, and hypothetically you had a neighboring town that wanted to refer that as a discretionary referral, right now there are no standards. If you voted for the standards, at least those you'd be on the record and you'd know which standards were going to be applied. Right now, if it comes in, we're in the same situation that we are with some other projects that we have now, which is very little review. It all becomes down to a benefits detriments analysis. And really, that's the way the Martha's Vineyard Commission reviews most of their projects, is with that benefits detriments analysis. And I would prefer to have standards on the record that are more clear and certain than just saying, well, we're going to weigh it.
Thank you. Okay, go ahead, John.
Sorry to be such a pill about this, but also on your decommissioning, it gives a 120-day standard, and there's been quite a bit of discussion about how that might impact the ability of any entity that wants to come forward with you, would be getting financing for it. Could you delve into that a little bit and why you came up with that 120 days and what impact you think that will have on any future project?
Well, it was difficult to arrive at that particular limit, but it was primarily based on a review and survey of actually smaller turbines that have been out of commission for a longer period of time. I would suggest that might be something that the commission would consider taking a look at the impact of that particular provision on financing moving forward. and show some flexibility there, and maybe extending it to 1 year, which I believe, at least based on some of my initial discussions, is enough time that there wouldn't be some financing issue. I mean, there have been issues in the past with ball bearing shortages that were not available for some of the larger turbines, and so they were decommissioned for a long period of time. The other option there is that that presently can be extended through by the executive director. So it doesn't have to go through the process, and it's almost like a minor modification one in a regular DRI. It's the same level of review. So it's not meant to be an impediment to financing. But if it's viewed that way, I think that that's something we could discuss in the future.
But we can't ask you right now to do anything to amend this. We have to just look at everything that's in place at this very moment and come to a decision as an assembly.
Yeah, but I mean, part of this is, we have the process that we have. And so we've got to work within that process. And just as we reviewed the November meeting, we'll review whatever the output of this subcommittee meeting and the full assembly meeting is next week. And having sat through the process with the commission and the questions by the commissioners, I think I'm in a position to have a conversation with the assembly about where the commissioners might be open to some changes and where they might not be. But to have it's ultimately not going to be sort of an endless discussion back and forth. And some of these finer points, we're going to have to make a decision. If you can't vote in favor of that, that's going to go back and it'll be subject to that process. But if we can talk about that as an area that we might look, we feel we have enough protection in there now because it's an efficient enough process to extend that 120 days. If we need something more certain, I think that is an area where the commission would be open to suggestions. So I'm just signaling that to you right now as part of this conversation.
Thank you.
We have other members of the Assembly here. During the meeting on the 13th, we'll probably suspend the rules to allow you to answer any questions from anyone of the Assembly who might have questions either before the Assembly convenes or by suspending the rules after the Assembly convenes, because it's quite complicated. Okay. So thank you very much. Not the 20th, I mean the 20th. Okay.
Could we get there was that report on what had happened with cell tower.
Just to provide you with a brief overview of our track record regulating cell towers. A threshold has been in place since January of 1997 for 35 feet initially. A couple years later, it was modified to allow for 80-foot monopoles. In that time, the Commission has reviewed 23 cell towers, 19 of which have been approved with conditions. 2 of those were municipal projects approved through a hardship exemption process. 2 projects were denied on a substantive basis, and 2 projects were denied on procedural grounds.
Thank you. We'll now go to comments from members of the public, and I'd like to advise you that to try to stick as closely as you can to the actual question in front of us, which is the 2 ordinances, the one with thresholds and the one with the specific regulations that those projects are going to be considered minimum performance standards. I don't want you to, just because there's a lot of people who have signed up, we want to give everybody a chance. I'd rather not go into long PowerPoint presentations. They're going to keep us here for a while. Try to be succinct and to the point. The regional policy plan includes a place for alternative energy sources on the Cape. So the Cape Cod Commission and the county is on record as supporting alternative energy. This is not a wind turbine or no wind turbine argument. It's a specific siting issue, what regulations are going to be considered, and how the process is going to play out. And just fairness to everybody else who wants to speak, I hope you'll try to keep your comments specific to what we're looking at today and not wander off too far. And if you do, I'll remind you and try to get you back. Okay, so we'll start with Carl B. Freeman.
My name is Carl Freeman. I'm from Orleans. One point I wanted to clarify is that with the wind reform siting bill, if a town wants a turbine for municipal use, it can choose to have the wind reform siting bill apply, or it can go by its own bylaws. It has that choice. I did want to say that a lot of the concern that this committee has heard is from the Falmouth situation, and I want to be very clear that I believe that turbines today are quite different. The technology of Falmouth is no longer used. That is called stall regulated, where the blades are actually fixed, and the wind, as it increases, blows across them and creates much turbulence. And today we have pitch regulated, where the blades actually turn in their socket. And the more wind there is, the less profile you see. And this is a much more efficient process and a much quieter process. The real-life examples I point to are in Hull and Portsmouth, and many turbines like that across our country and other countries. In Hull, there are people who live 750 feet away from the turbine. They have no complaint. In fact, within 1,800 feet of the Hull turbine, there are 350 homes. There's an average of 2.5 adults per home. That means there are there's about almost 1,000 people that live within 1,800 feet of the Hull turbine that don't have a complaint, because the sound produced is different. In Portsmouth, there are people that live 736 feet away. They don't have complaint. There's one complaint at 1,000 feet. And why I'm leading into this is because I suggested this before. Your best test, your best litmus test for where turbines should and shouldn't go are existing examples. That can eliminate a lot of the guesswork, a lot of the maybes. You can look very quickly and see if this is a turbine like the one proposed, and compared to one existing, you can see what the effects are. Of course, we can account for denser vegetation or less dense. There's a lot of little variables, but the main variables are in place, and you can look at them. It is the best, most effective means of eliminating places for wind turbines to find a safe one. And towns are suffering terrible financial crisis right now, and wind is the most effective way for them to deal with this and to impose onerous regulation. And I think this could be called onerous in that I've heard some Cape Cod commissioners say that any impact is a minimum impact. And when we have that subjective term of minimum impact, and commissioners saying that any impact is too great, then that scares me as someone that wants to see wind go forward, well-sited wind go forward. I don't want to see things like Falmouth go forward. I support the people of Falmouth. I think they need better solutions than they have had. Denmark is about the same size as Massachusetts. They get 30% of their energy from wind.
We're not planning on regulating the Denmark wind turbines. Okay, we have to try to, I don't mean to use you as an example.
To wrap up.
We can't wander off too far.
To wrap up. As I said, I suggested that you look at what actually is out there and go from that as your first, and also, Falmouth did not have the best of sound testing. Conservative sound studies. This is what the commission, I believe, should look at. You need conservative sound studies. You need to ask the spectrum of sound study professionals and find out where the standards are, the ones that will result in better studies. Thank you.
Mitch Rellin, and if you're not here representing only yourself, if you represent a group, just mention that. We'll presume you're representing yourself unless you tell us otherwise.
My name is Mitch Rellin. I'm a Brewster resident. I'm also the president of Brewster Citizens for Responsible Energy. And I came to speak in support of the threshold and performance standards. I didn't come prepared to speak about the Brewster project. If I could just make two comments, because there's been a lot said. One is, I'm not a lawyer, but after speaking to a lawyer, my understanding is that since the planning board, their vote essentially was a legal denial, then that process has ended. Anything henceforth would be a new project. And the other comment I want to make is, the initial votes at town meeting were for the concepts, renewable energy, clean energy. Who wouldn't vote for that? It wasn't until October, November of 2010 when the details came out that we as citizens looked into it and became concerned. And again, that's why we are in support of the threshold and performance standards, because the details need to be looked at. Town by town, the process for permitting and the bylaws, often they're inconsistent and maybe outdated, and that exposes the residents of these towns to a variety of influence, whether it's outside influence, such as the state pressure to increase the amount of renewable energy, or internal pressures, such as financial. Money should not affect people's lives, but it is. And the wind turbines and wind power on Cape Cod, probably across the country, it's no longer an issue for the individual towns. The proposed Dennis turbine at the Water District would be within 1,700 feet to the nearest Brewster resident. This is not just an isolated town event. The size of turbines, the technology is increasing constantly and rapidly, and that's going to affect noise and flicker issues. Individual town board members, it may be difficult for them to keep up with the increasing size and technology. We look to you. We look to you and to the commission and for the performance standards to protect the residents in all of the towns here. Thank you.
Thank you. I think speaking of the Brewster experience, my understanding, if I understand the executive director, is that the decision by the planning board could be appealed legally, and if it is, then what the outcome of that would lead to would be a different outcome than if you go the ordinance route in the warrant. So it's conceivable that from this standpoint that would not trigger additional Cape Cod Commission.
Thank you again. I'm not a lawyer, but the CVEC and the town had the 20-day period following the decision by the planning board to do the legal appeal. Again, I'm just sharing with you what I understand. Thank you.
Mark Kuhl.
Mark Kuhl, West Falmouth. Thank you for having me. And I've tried to gain a larger perspective upon beyond that of the pressure headaches and the sleepless nights as to the consequence of these proposals. I've concluded that I do support both the proposals. They provide a transparent review process that minimizes municipal conflicts of interest, a better level of protective mechanisms ensuring public safety, a better measure of technical aspect in keeping with the Assembly's fall request, and an avoidance of state intervention assuring that wind issues on Cape Cod will be resolved on Cape Cod. And lastly, a flexibility which will promote an evolving working balance between public welfare and developers. Flexibility is the key to why I came to this conclusion. If the trigger and standards before you are the necessary step before making available the review step in project benefit versus detriment test, then on behalf of my wife, I say let's get on with it. The advent of state policy regarding wind energy is unique in that there's no state policy. The state promotes unimpeded wind development, as Falmouth is finding, with no state guidance when there's a hiccup. The state has provided a good thing, however, by giving a specific role in its renewable energy campaign to the Cape Cod Commission. That role can be acted on only if standards exist and are on the books. Last fall, the Assembly took issue with the leniency of those standards. Good for the Assembly, and I thank you for your protection. These standards have been returned with more teeth per the Assembly's request. It is time to progress to the next stage. The Cape Cod Commission wants regulatory authority on land-based wind development instead of the status quo. The status quo has helped no one in Falmouth and leaves little hope for concerned citizens elsewhere on Cape. The Assembly has the opportunity to remove this static purgatory. There is one further concern that I do have, and it's about the 65-foot triggering threshold. As written, a clause in the proposal affords a waiver of sorts if a town develops a Cape Cod Commission certified wind bylaw. I would warn the Assembly not to entertain this waiver clause. Towns are in the throes of hard economic times. Look at Falmouth, and potentially Brewster, Dennis, Bourne, and Wareham. Project petitioners appeal to the community with framed issues of beating back climate change and oil dependence, all the while disguising a trend towards sacrificing neighborhoods for town revenue. No one can adequately check the checker in Town Hall. In other words, it's a conflict of interest. The Cape Cod Commission and its third-party perspective on this issue is the appropriate arena for regional policy standard and enforcement, review, protection, transparency, and the promotion of future land-based wind projects move ahead only if standards exist. We need them to move. The proposals that are both proposals that are before the delegates, the minimum performance standards are not the end-all regulations on this ongoing debate. The staffers will continue exhaustive efforts and uncover emerging impact research. But now, it's time to protect the citizen again. It's time to take the necessary steps. So I urge the Assembly to support both proposals as written. Thank you.
We'll also have several comments that you sent to us to read or to be submitted into the public record. We'll do that along with the other comments if so requested.
Thank you very much.
Okay. Barbara Hill. Oh, okay. Well, why don't we go to Sarah Cote? Are we going to get Barbara Hill? Is she here? I would have called you back after the. Okay. You wouldn't have lost your spot.
Very much.
Okay.
Good afternoon. My name is Barbara Hill, and I serve as the Executive Director of Clean Power Now, a nonprofit based in Hyannis that whose mission is to inform, educate, and empower citizens to support viable renewable energy projects and policies. And we have over 16,000 members, with 4,000 of those based in Cape Cod. On March 15th, 2011, 12 signatories sent a letter, I'm out of breath, I'm sorry, to the Barnstable County Commissioners informing them of serious objections to the Cape Cod Commission's recently proposed revisions to enabling regulations and minimum performance standards for wind turbines on Cape Cod. In addition to Clean Power Now, the signatories include Cape and Islands Self-Reliance Corporation, Mass Audubon, the Town of Barnstable Renewable Energy Commission, the Town of Barnstable Energy Coordinator, Brewster Board of Selectmen, Town of Mashpee Town Manager, Brewster Energy Committee, the Dennis Alternative Energy Advisory Committee, Falmouth Climate Action Team, Falmouth Energy Committee, and the Harwich Utility and Energy Conservation Commission. All signers believe that the revisions to the review thresholds and the MPSs are unacceptable, as they are technically incomplete and inconsistent with the energy policy goals and standards in the regional policy plan. I just want to note that we made specific recommendations. I will get that letter to all of you, so I won't have to repeat those today. The RPP acknowledges the threats to the Cape's environment and economy due to reliance on fossil fuels and climate change. It explicitly supports the development of distributed renewable energy sources, including wind, and calls for streamlining of permitting and incentives to achieve that goal. As we have witnessed over the past 6 months, many local and regional decision makers are bombarded with emotionally driven arguments in opposition to proposed wind energy installations, much of it inaccurate or incomplete. We understand that it is a challenge to weed through what is fact and what is fallacy on the topic of wind energy. This leads us to the recommendation that you reject the proposed revisions, and we urge you to consider county engagement in a collaborative process that will result in a policy and a set of standards and thresholds that balances the objectives of all constituents and encourage the responsible development of wind energy projects on Cape Cod. We believe that Barnstable County should not set the precedent of implementing policy that essentially encourages only small wind energy installations and effectively proves to prohibit large or mid-scale installations. We propose that you join with us in co-sponsoring a third-party facilitated consensus-building process to design well-informed, fact-driven wind policy for our region that would enable decision-makers and other stakeholders to design the goals together. This consensus-building process around responsible wind energy policy would also be beneficial in exploring the topics of the proposed Massachusetts Wind Energy Siting Reform Act. May I also note that this would be of no cost to the county. We look forward to working with you to create an acceptable, third-party, facilitated, consensus-driven wind energy policy, as well as a new set of draft enabling regulations and minimum performance standards focused on high-quality scientific sources representing a broad spectrum of stakeholders. Thank you.
I just wondered, do you feel that it's the Cape Cod Commission members who are anti-large wind projects, or do you think it's the staff that's anti-large wind? And which exact standards are preventing?
I think the threshold itself, I don't think it's the staff or I don't think it's any person. I think it's the standards and the thresholds, and these 12 signatories also believe that the swinging of these threshold, the lack of a threshold and the swinging of these standards to where they are today, it kind of went from a place to another place, which...
So it was the emotions of theirs that did this?
I think there has been a lot of emotional conversations around all wind energy installations on the Cape, and I have been involved in an emotional stakeholder process around another very controversial project for many, many years, and I've seen consensus, third-party facilitated consensus-building processes work very, very well when all the stakeholders at the table, including Cape Cod Commission, the county, the commissioners, and other important stakeholders that need to be at that table to discuss how to responsibly site wind energy installations.
Yeah. Paul?
Do you and the groups that you represent feel that you did not have the opportunity to have input into the standards and the thresholds that were considered?
No, we've been at every level of making suggestions at every one of the public hearings. We feel that we have been participating in the process. That's why we're here today, participating in the process. But I think that there's great value in looking at how this process has unfolded and maybe saying, let's take a step back and maybe create another type of, set another table with some other constituents and stakeholders that could potentially add tremendous value to this discussion and come out with a better document and a better set of standards.
Thank you.
Thank you.
Sarah Cote?
Good afternoon, and thank you for this opportunity to comment. My name is Sarah Cody, and I currently serve as the Executive Assistant at Clean Power Now. I would like to echo the comments of our Executive Director, Barbara Hill, who spoke before me, and the signatories she represents. A stakeholder process would allow everyone to have a seat at the table and result in well-informed, fact-driven policy. The Cape and Islands region has some of the best wind resources on the eastern seaboard. There are also excellent local organizations that collaborate well on the development of regional strategies. For example, in 2006, the Cape and Islands Renewable Energy Collaborative conducted a Beyond Cape Wind stakeholder process. This effort resulted in the establishment of consensus-driven energy goals for the Cape and Islands region. The first goal states that the region can and should become a net exporter of renewable energy by 2030. The second goal is to reduce our fossil fuel consumption for transportation and home heating by 50% by 2030. It was agreed that wind energy, both land-based and offshore, is needed to play a very large role in our attainment of these goals. The proposed minimum performance standards are focused on public safety, visual, and noise impacts. The proposed review thresholds and standards are excessively strict and not reasonable. Furthermore, while these are important factors, potential natural resource impacts and mitigation should also be considered. For example, setbacks from breeding avian habitat are appropriate for projects located in the habitat of rare coastal birds. Current state regulations under the Massachusetts Endangered Species Act and Wetland Protection Act do not provide for review or conditioning of projects adjacent to coastal water bird breeding habitats, only projects located directly within designated priority habitat or wetlands. This is a gap in regulation that the Commission could address in its DRI review process. Wind turbines also have the potential to affect populations of species of birds and bats in addition to rare species, particularly during migration along the Cape Cod coastline. Again, thank you for this opportunity to comment.
Just in the future, if you have an organization that's represented here, I presume that you'll have one representative, we don't need 3 or 4 from the same group, just time constraints, but thank you very much. Preston Ribnick.
Good afternoon. I'm Preston Ribnick, and I live in Wellfleet, and I thank you for the opportunity to speak this afternoon. I've spent much of the last year researching wind energy. I've read hundreds of articles and documents and spoken with people throughout the United States and around the world. And I come here today to this subcommittee to implore, or the committee to implore, the Assembly of Delegates to approve the minimum performance standards and recommend them to be approved by the full Assembly of Delegates next week. Industrial wind-sized turbines, those up to 500 feet tall, certainly qualify as developments of regional impact projects and therefore must be regulated and reviewed by the Cape Cod Commission. In fact, I left in many of your places, and people in the audience probably saw just a couple days ago, maybe even yesterday, a front-page article concerning what's occurring in the town of Dennis. And I'm kind of shocked that you had some of the representatives from Brewster here today, including the chairman of the Board of Selectmen, who wouldn't see the absolute necessity for the Cape Cod Commission to regulate these types of projects. Because you see on the Cape Cod Times map that was on the front page that the 2 proposed wind turbines by the Dennis Water District is actually right on the line of the Brewster and Harwich. In fact, if you look at the legend at the bottom, it looks like it's 1/16 of a mile from the Brewster line and about a quarter of a mile from the Harwich line. And because of their massive scale and their ability to broadcast adverse impacts over a broad expanse, it's entirely appropriate that wind energy facilities should be considered these developments of regional impact. Numerous past and current wind energy proposals have envisioned installing these facilities on town boundaries, as you see in the situation with Dennis and Brewster and Harwich, or in areas that have a significant impact on residents of neighboring or abutting towns. The residents in these communities are currently completely disenfranchised by the current local regulatory system, which affords them no participation in the decision-making process that promises to have a profound impact upon their lives as the people in unfortunately in Brewster and in Harwich are now living with because of the water district proposal in Dennis. The commission would consider the impacts upon the commission will consider the impacts upon the entire region, including those residents who lie on the wrong side of the border from the host town, a mechanism that is clearly justified and which is currently absent. I certainly do not have the time today to state all the many reasons why the Assembly of Delegates will hopefully approve these minimum performance standards next week at their meeting. Many other speakers have and will address the multiple reasons, but I will state with absolute confidence that incorrectly cited wind turbines represent both a clear and present dangers to the residents of Cape Cod. What has happened in Falmouth is not an isolated event. People are being made ill by industrial wind turbines all over the world. There is a massive and growing body of scientific and medical evidence on the negative impacts of inappropriately sited industrial wind turbines near where people live, work, attend school, or are being cared for in healthcare facilities. Please vote today to recommend to the Assembly of Delegates at next week's meeting to approve these minimum performance standards. And here's my one more thought. Here's the most important thing I will say. And if the Assembly votes to remand the standards back to the Commission as they did in November for further revisions, then I urge the immediate implementation of a one-year moratorium through the DCPC process. I thank you.